The Federal Trade Commission voted 3-2 to ban non-compete clauses in the United States. Today, I'm going to break that down for you, what it means for veterinarians, what it means for veterinary practices, and what is coming in the future. This could be a massive shift for veterinarians and the employment law world. But this is an evolving story, so you'll have to stay tuned with us as the information comes out. Okay, a little backstory. About 3 years ago, an executive order from President Biden was issued to the FTC, telling them to investigate non-compete agreements in the United States. Based on that mandate, the FTC published a proposed rule in January of 2023 and opened a notice and comment period. The rule proposed a comprehensive ban on non-compete clauses for employees. During the last year, more than 26,000 Americans submitted comments, some of which were submitted by veterinarians. On April 23, 2024, the 5-member panel of the FTC voted 3-2 and simultaneously published a rule essentially banning non-competes for employees and workers. Under the new rule, essentially all non-compete agreements are banned for workers, and that means employees and contractors. The only exceptions are non-compete agreements for senior executives and non-competes that are entered into during the sale of a business. So effectively, all employee non-compete agreements are going to be banned, which includes most veterinarians that are practicing as associates. Under the rule, if allowed to proceed, any existing non-compete clauses that were already signed will be unenforceable retroactively. New non-competes, written after the ban goes into effect, even for senior executives, will be unenforceable as well. Non-compete agreements for senior executives that were in effect before the ban will continue to be enforceable. As an aside, senior executives are defined as those making $151,000 a year with policy-making authority. Now, this definition could allow some veterinarians in medical director positions of private practices that currently have a written contract to still have enforceable non-compete clauses. Okay, a little deeper dive there. The rule specifically bans non-competes for employees that make decisions at a subsidiary level. So hospital medical directors within a large multi-location group practice would not qualify for the senior level executive exception and not be subject to their non-compete clause. Okay, back to the exception for sellers of practices. This would allow non-compete clauses in partnership agreements, buy-sell agreements, and asset purchase agreements to be enforceable. Now, this follows current law in many states, which separates employees from former business owners and partners when it comes to the enforceability of non-compete clauses. Okay, let's take a little deeper dive into the rule itself, starting with the definition of non-compete clauses according to the new rule. A term or condition of employment that prohibits a worker or penalizes a worker or functions to prevent a worker from seeking or accepting work in the United States with a different person where such work would begin after the conclusion of employment that includes that term. So let's break this down without the legalese. This is saying that any clause that creates post-employment restrictions that would penalize or prevent a worker from seeking or accepting work is banned. Basically, anything contractual that stops an employee from working in the future will be unenforceable in court. And this is important because there's nothing about air mile radius or geographic restrictions, which are the hallmarks of the traditional non-compete clause. There's nothing about restricting the scope of the work, which is a big deal in veterinary medicine with the broad range of practices, from companion animal to production animal, specialty practices, from day practice to emergency practice. There's nothing about a reasonable time frame. This refers to any agreement that prohibits work in the future after the termination, the stop of that current employment. So I point this out because if not written correctly, non-solicitation agreements and non-disclosure agreements could be wrapped into this ban. Now, most veterinary contracts have non-compete agreements, non-solicitation agreements, and non-disclosure agreements working together within the same contract as independent clauses. So if you're a practice owner or manager, you'll want to review those agreements and to see what protection is still in place. If you're an associate, you'll want to review your agreements to see if they truly prohibit you from taking a job after employment. Now, of course, the details are fuzzy. It would take multiple court cases to figure out exactly where this definition is, what it means, and where the lines of enforceability and unenforceability actually lay. Okay, a few more details about the ban. If a practice's workers are subject to non-compete agreements or this ban, the employer has 120 days to post a notice that these non-compete clauses are no longer enforceable. For practice owners, managers, medical directors, this means they should review their contracts and post that notice. There is a sample form on the FTC website that will help you write this notice. On the associate side, if you currently have a non-compete in place, don't burn your contract just yet. This does not mean that your non-compete clause is gone, effective immediately. This ban only takes place if the ban is allowed to proceed. So with that, let's look at what's also happening concurrently. As of April 24th, 2024, a lawsuit has already been filed by the U.S. Chamber of Commerce to block the FTC's ban. Other organizations and businesses plan to file lawsuits as well. These lawsuits are seeking a temporary restraining order against the FTC from enforcing the ban. The lawsuits claim that the FTC doesn't have the authority and the jurisdiction to rule on non-compete clauses. Legally speaking, non-compete agreements have historically been governed by the state's legislatures and state court systems, not the federal government through an agency. It's debatable on whether Congress actually granted power to the FTC to rule on this matter. In my opinion, this ban will be delayed in the court systems for months or even potentially years. The court cases will be very interesting, and they will be highly contested, and they will likely take years to fully resolve. So before you go crumpling up your contract and looking for a new practice, watch these court cases and watch this legal action unfold. As a reminder, veterinarians and veterinary practices still have to watch their non-solicitation and their non-disclosure agreements, and it's unclear how this ban, if allowed to take effect, would impact those non-solicitation agreements. To put it mildly, this puts the world of employment law on its ear. Many lawyers, including myself, are trying to figure out how this affects our clients and how this will affect the laws moving forward. So stay tuned to Drip.vet and Vin to bring you the latest news and analysis on how this legal maneuvering will play out. Obviously, this is affecting tens of thousands of veterinarians and practices, and this is a massive story for our profession. If you are a veterinarian restricted by a non-compete, this is something you're going to want to pay very close attention to.